everything. The generals control everything. There are few users. And when I was there, I told them, you know, you can get the SIM card for free in my country, but or virtually for free. Well, I mean, they will load it up with all the goodies. But that is because it is leveraged upon millions of subscribers in our country. The beauty of a free market and the use of the mass sales of services. Well, for postpaid, of course, it is identifiable. Again, there is a way to trace identity even with prepaid subscribers. All that the prepaid, if you prepaid guys think you're safe, you're not. All that the PNP would have to do is wait for you to make the mistake of calling one postpaid subscriber. The moment they trace the postpaid guy, they can ask that guy who called you from this number. And well, of course, assuming that the person you called is only happy to rat on you, you are, you know, we will be able to trace the information, the identity. Call data record. So this is the typical retention period. If it's prepaid, it's 2 months. It's postpaid, it's 6 months, half a year. And again, the reason for the longer retention period for postpaid accounts is more manageable. There are fewer of them. Second, for billing purposes, these are the guys who can complain, right? I mean, you can complain about mysterious charges to your phone. And so for the postpaid services, there is actually a content-neutral, routine, business-related purpose for a longer retention period. And as Detlef stated earlier, you need a longer retention period for investigative purposes. In other words, you need the evidence to be preserved for a longer period so that eventually, if it is needed, the law enforcement officers will have time to get to secure a warrant. And then we have the log of the transaction. And the log will contain, and look at the bottom, location of the base station or switch. That is the key for identifying for Jun Lozada exactly where he was at the time he made the phone calls. We have a slide specifically for that. We proceed now to the content. There is no record kept of the content. The telcos were categorical about that. In fact, that is actually bad news for the law enforcement officers. If after the fact, they are told, can we get information, the content of a certain conversation or text, it is too late. And therefore, the only way to access content is through a prior arrangement. And as I've told you, the proper way to do that is to get a warrant. And there is technology to intercept these messages in case that warrant is secured. But again, that intercept technology is not required by the National Telecommunications Commission. In other words, it is very expensive technology, and it will have to be ordered by the government. I asked Smart and Globe, are you prepared to do this? Of course, their answer is, if we're ordered to do it, we will. We will spend the money. I said, will you be able to afford it? The stock answer, I don't think they would like to be officially quoted on this, is they say, we just pass on the costs anyway to all the subscribers. And again, from a public reason, the reasoning of public policy, for me, maybe we should all be prepared to pay that price, because that is the additional cost that we pay in order to secure our safety. I mean, why should we be stingy and niggardly about technology that is needed anyway to secure our safety? Let's proceed to the next. And here we get to the Jun Lozada episode. You see, if you're a postpaid user, your bill every month will show information about where the call was made. Technically, it's actually the first cell site that was used by your call when you made it. But in the episode with Jun Lozada, he was kidnapped at the airport and brought back and forth on C5. Quite obviously, he would have used several cell sites. And the way it works, according to the telcos, is that technically that information in your billing statement is not of the cell site, it is of the switch. And there is a main switch that sort of monitors the transfer of your call from one cell site to another. So if Lozada was driving from Ortigas all the way, from Santa Rosa all the way to Ortigas, you're pretty sure that his phone call will be switching from one cell site to another. From Santa Rosa to Alabang, to Bicutan, to C5, to the Fort. And that will be recorded by the computers of the telcos. In other words, we can, assuming, well, just hypothetical. It is hypothetical at this stage. Assuming, in fact, he was disappeared, we can tell exactly where he was at any given moment. And the location of the user is one key information that is available from the telco, not from your, obviously not from your handset. So if you think there's any other piece of information that can be derived from the cell phones, feel free to just tell me. We have an open forum later. Thank you, Beck. So I will now proceed to the constitutional framework, and I will have quotes from the EU directive that Detlef described to you earlier. Let's proceed. These are conceptual distinctions. The author, Oscar Tan, at that time a law student, when he wrote the first part of this essay in the Philippine Law Journal, said that the danger in Philippine law is that we keep on quoting the right to privacy, but we don't make a distinction between information privacy and decisional privacy. Decisional privacy is like reproductive rights. That would be decisional privacy. It would be like I don't know if I remember the Kagandahan case. Is that the guy who had the sex change operation and wanted to change his name? In other words, decisional. We use the word privacy often in constitutional law, but we have to identify one strain which is specific to information privacy, and often we mistake one for the other. We keep on invoking. Well, actually, the Supreme Court keeps on invoking the right to privacy without making this fundamental distinction. It was applied for the first time by Mr. Tan, well, by Attorney Tan, in that article. It was adjudicated in one Supreme Court case, information privacy, Oble versus Torres, the proposed national ID, and the court struck down the national ID requirement, saying that it will reveal too much information to too many people. In other words, it was not just how much information was available, but how many people can get to see that information. And we adopt the American rule. Our constitutional provisions on this are borrowed lock, stock, and barrel from American law, which says that the right to privacy protects persons, not places. In other words, the mere fact, and this is a recurring argument, that your message goes through the airwaves, which is public domain, does not diminish your right as a person, because your right to privacy inheres in you as a person. The next one, please. These are constitutional provisions. You're familiar with them. But the first is the right to due process. The second is the right against unlawful search and seizures, which means that that is where the search warrant requirement is codified. And the last is the privacy of communications and correspondence. We will now proceed to the key statute dealing with this, which is the anti-wiretapping law. This was passed in the 1960s. In fact, just to show you, the last two lines of this slide says that there are devices known as the walkie-talkie or the tape recorder. In other words, at that time, that was the high-tech stuff for them. Now kids, kids have this toy, this Motorola walkie-talkies. And at that time, it was used only by detectives and James Bond.